Thank you, everybody, for coming out to this inaugural meeting of the Lincoln Douglas Society. We're doing this in my home because we've only just recently, a couple days ago, gotten approval to be an actual on-club event here at Cornell Law School. So the next meeting will hopefully be in a room on campus. But for our first meeting, we're doing a little bit more intimate gathering here at my place. The topic today is going to be very interesting. The resolution before this body is resolved, abolish qualified immunity. We've got two excellent speakers today who are going to give good talks both for and against the motion. The format is going to be relatively simple. Each speaker will get around 15 minutes to make their case in chief, and then they'll get around 5 minutes to rebut the main point. After which, there will be a vote of this body, and we will choose to either adopt or reject the resolution. Without any further ado, I'd like to introduce our speakers, Jesse Gervasio and Troy Anderson. Jesse has won the coin toss, and he is elected to go first. So I'll let the speakers introduce each other, and we'll get started.
All right. Since Jesse is going first, I will go ahead and introduce you first, and we can go from there. So, speaking in opposition to the motion, that means he is not in favor of abolishing qualified immunity. Jesse Gervasio is a 3L law student at Cornell Law School, a native of Goodlettsville, Tennessee. Jesse attended the University of Louisville, where he studied English and creative writing. Jesse is the president of the Cornell Law mock trial team and won first place at the 2023 Peter James Johnson National Civil Rights Mock Trial Competition. He has worked for the Nashville District Attorney's Office and in the Special Narcotics Division of the Manhattan District Attorney's Office. Jesse has a strong interest in civil rights and criminal justice and is vice president of speakers at the Cornell Federalist Society.
All righty. Thanks for that introduction, Troy. I'll go ahead and do yours now. So speaking in favor of the motion is Troy Anderson. He's a 3L law student here at Cornell. A native Arizonan, Troy attended Arizona State University, where he earned 2 degrees in philosophy and political science. Through ASU's Capital Scholars Program, Troy worked for Senator Jeff Flake and was active in student government, becoming student body president of ASU Polytechnic University in 2020. Troy serves as executive editor of the Cornell Journal of Law and Public Policy, and most recently worked as a summer associate at Woods Oviatt Gilman, LLP. Troy has a strong interest in civil rights and criminal justice and has earned the Cali Award for Professor Zeldin's criminal defense class. Good luck.
Good luck. You'll do great.
Okay. Do I start whenever?
Yeah, and if you'd like to stand. Or if you'd like to not stand. It's okay.
So I'm arguing in the negative today, which means that I think qualified immunity should not be abolished. Now, in arguing in the negative, I'm not here to say that every qualified immunity case speaks towards qualified immunity being good doctrine. Like most, legal doctrines, there are cases where we might say it goes wrong. There are cases where we think, this comes to a good resolution. I'm only here today to say that if we have to err on the side of abolishing qualified immunity or not abolishing it, we should not abolish qualified immunity. Okay, so being that I'm going first, I am going to sort of go over what qualified immunity is and, get our terms straight and sort of go over the background of not only what it is, but where it comes from. So qualified immunity essentially protects government officials, including police officers, which is probably going to be the bulk of the discussion today, from being held personally liable in civil cases, unless they fail a two-pronged test. Now, that two-pronged test is, number one, the official violated a constitutional right of someone. Number two, that official knew that their actions violated a clearly established right. Now, that second prong, the clearly established prong, that's sort of the bulk of the controversy when we talk about qualified immunity. And I'll get into that later. I'm sure Troy will probably get into that later. Basically, a lot of people have a problem with this clearly established right clause because there are a lot of rights that under qualified immunity, it's hard to determine are clearly established. But for now, that's what that's our definition for qualified immunity. And I want to start off by, kind of narrowing the scope of what this is. A lot of people, when they start to talk about qualified immunity, they lump in criminal cases, some of the more egregious forms of police conduct. That, in my opinion, is not really probative to the discussion we're having today. Qualified immunity is really only about civil cases. So it really only applies to civil rights violations, and it's important as well that we keep in mind that this isn't just a police officer thing. Police officers are where we're going to spend the bulk of the discussion, but this applies to other government officials as well. So a little bit about the history of qualified immunity. When was it created? It was created in 1967 by the Supreme Court. So this is judge-made law. It was created in a case called Pearson v. Ray. And it was created in response to what are known as Section 1983 claims. Now, Section 1983 claim basically says that you can file a lawsuit against a state or local government official for violating your federally protected rights as an individual. These cases go to federal court, and you can be compensated if your right was violated. Now, Pearson v. Ray was a Mississippi case from 1967. The police officers there were enforcing an anti-loitering statute against protesters. Now, these protesters knew that they were going to be arrested. They knew that they were violating the statute and that the cops would arrest them. And that was sort of the point. They wanted to protest by being arrested and sue these police officers. And not only did they sue the police officers in this case, but they did sue the judge as well for finding them guilty. Now, judges are not held liable for the decisions they give. And that's sort of because it's their job to give those decisions. And if every person who was found guilty by a judge could sue, then not a lot of people would want to be judges. And that sort of logic kind of maps onto why officers and other public officials were eventually granted qualified immunity. But in this case, the officers basically say, we're not, we don't want unqualified immunity. We don't want absolute immunity. We're just making a good faith defense. They were basically saying, we should not be held liable. We've acted in good faith. We were just doing our job enforcing this statute. We made this arrest because it was our job and because it was a split-second decision. And so the courts held in Pearson that the cops can be granted a defense if they acted with good faith and with probable cause. And that's sort of the origins of where we get qualified immunity for. So that good faith defense sort of was a government official's way of defending themselves from Section 1983 suits. So why? Why do we need qualified immunity? That's sort of the question. The logic is we want to protect government employees from frivolous lawsuits while holding them accountable when justice deems it necessary. So when we talk about frivolous lawsuits, one thing that's going to come up often is we don't want individual police officers to be burdened with this threat hanging over their head of I might be sued and incur financial loss if I make a split-second decision that ends up violating someone's rights. Now, that's one segment of why we need qualified immunity. I really think that the core of qualified immunity comes down to split-second situations where officers have maybe 2 or 3 choices, all of which could end in bad outcomes, and they have to pick what they believe, based on their experience, is the best outcome in that split second. I think really that's why qualified immunity is necessary. I think it helps cops do their job in a way that not only protects them from those split second scenarios, but in some cases protects the public who's in danger. So that's sort of the origins of qualified immunity. But like I mentioned, it's the second prong, that clearly established rights prong that most people have problems with. So that comes from a case called Harlow v. Fitzgerald. That's where we get the Harlow test that the second prong comes from. That case was about an Air Force Department official who sued President Nixon and some of his White House aides because he thought that he'd been fired for essentially being a whistleblower. So basically what we get out of this case is that second prong, that not only does the officer or official have to have violated a constitutional right, but they have to have had reason to know that this was a clearly established law. So no more litigating subjective good faith after Harlow. We're just litigating the objective, reasonable reason that the officer would know that this was a clearly established law. And Harlow was an 8-1 decision. Chief Justice Berger was the only one that dissented. So that whole, lingo of sufficiently clear for a reasonable person to know that this was certainly a right. What exactly does that mean? So when we map that logic onto police officers, sort of the problem that comes up with qualified immunity is that in a lot of cases, the courts will ask to find an analogous case so that the police officer can say, that there was not an analogous case like this. I couldn't have known that this was a clearly established right. So what does that look like in practice? So there's a case called Pearson v. Callahan from 2009. In that case, there was something known as the consent once removed doctrine, which basically means there was an undercover informant buying drugs from someone in their apartment. This person sold the undercover informant drugs, and in other jurisdictions and in many courts, there was a law that said that consent, when you let an undercover agent in, maps onto the other police officers after that sale. So they went in without a warrant, so the other police officers did, and they were sued for a civil rights violation. Basically, what the court said in that case is that there wasn't another analogous case from that jurisdiction that says that the cops couldn't have done this. So the cops didn't know that they were violating this person's right because in other courts, it had been held that that was okay. So qualified immunity mapped onto Pearson there. But there are other cases where they will find analogous cases and the cops will be deemed to have, that you should have known that this was a clearly established right. So one of those is Hankins v. Wheeler from 2024, actually, earlier this year. In that case, an officer stopped a car driver. He claimed reasonable suspicion because there were a couple of other guys in that car who were sort of hanging their heads out the window and they were driving slow and they had been driving for a long time like that. The officer claimed reasonable suspicion. He called another officer and that officer pointed his gun at the driver. Now, when they had to talk about it, the driver said that they were just looking for their lost dog, and that was the case, and they let them go. But they were sued, obviously, for violations of civil rights, and in that case, the court did not find that qualified immunity would attach because there were several analogous cases that say that you can't do something like that and that that's not reasonable suspicion. So that's how the second prong kind of works out in practice. So the current status of qualified immunity right now, there's really only one judge in the Supreme Court who is willing to offer a challenge to qualified immunity. There was a case called Baxter v. Bracey, and this is sort of where that second prong comes in again, and we can see why it's controversial in some cases. So Baxter v. Bracey was a Tennessee case. There was a man who had committed a burglary, and the cops were chasing him. They chased him until he couldn't run anymore and surrendered, and he put his hands up. And by that time, they had let go of the dog, their police dog. The police dog ended up biting Baxter in the arm and injuring him. And the police officers, the individual police officers in that case, were sued. So they went back to see if there was an analogous case, to see if the cops should have known that this was a clearly established right. And what they found was a case where the cops had let go of a dog while a man was surrendered on his stomach. So in Baxter, the man was standing. In this analogous case, the man was on his stomach. The court found that they weren't analogous enough because of the differences in circumstances. Now, a lot of people would say that that's a trivial distinction to make. Again, I don't have to defend every case of qualified immunity here today, but I will say based on an officer's experience, it does make sense that a change in the fact pattern in that way would, constitute different circumstances. I mean, if this guy they've chased him, they know he's a burglar, he might present, a danger to the public in a way that someone who is surrendered on their stomach doesn't. Now, again, that's a hard one to defend. There are a lot of hard ones to defend. There are a lot of ones that turn out really well. That's kind of the nature of But what's important about Baxter v. Bracey is that it was denied certiorari by the Supreme Court. there was actually only one justice who dissented from that denial of certiorari, and that was Justice Thomas. So Justice Thomas is maybe the surprising challenger of qualified immunity, but he really is the prime challenger right now. Thomas's issue is really from an originalist perspective. He says that basically, if you look back to Section 1983, when it became law, there was no mention of immunity or defense. But the counter argument to this is that there are cases from the 1800s that establish a good faith defense for police officers and for some public officials. So it's sort of rooted in the common law is the counter argument to what Thomas is saying, and it's incorporated through the common law into 1983. Now, the second prong is sort of an extension of that, but that's sort of the counter argument to Thomas's claim that there is no originalist interpretation of qualified immunity. All right, so a couple of statistics. From 2011 to 2015, there were 458 appeals a year for qualified immunity. That number went up to 555 from 2016 to 2020 per year. Now, qualified immunity, according to a study from several circuit courts, is really only granted in 54% of appeals. So I think a lot of times when people talk about qualified immunity, they talk about it like it's this bulldozer that is just trampling over people's civil rights. And I don't think that's the case. It's only granted 54% of the time. And let's not forget, too, that this applies to government officials broadly. So if you heard, 555 cases a year, 400 a couple years ago per year, I think a lot of people in their heads imagine these as all police officers because that's the bulk of the qualified immunity debate is what it means for police officers. But qualified immunity applies to government officials broadly, and there are a couple that I think we do want to have qualified immunity and that I don't hear arguments for taking away qualified immunity for them that often. So firefighters and EMS. EMS is actually, they use qualified immunity quite a bit. There was a recent case called Buckley versus Hennepin County. This was an 8th Circuit case where basically a woman was having a panic attack. She was on cocaine. The paramedics took her in the ambulance to try and get her help, and she started kicking and biting at them. So what they did was they forcibly restrained her and they subdued her with ketamine. Now she was sued. She sued the EMS people after this to try and claim that they had violated her civil rights. Now, most other circuit courts also agree that qualified immunity should map on here, and it did in this case, in this 8th Circuit case. So I think that's, we talk about this a lot as it pertains to police officers, but I do think there are other government officials that should be protected from frivolous lawsuits, including those kind of lawsuits. Now, there are also teachers who use qualified immunity. Sometimes a teacher will have to go through a search and seizure of a student if there's no one else nearby that can do it. There are cases where students have had drugs on them or they've been suspected to have drugs on them, and the teacher has to make a split-second decision if this is a danger to the rest of the school. Do we search this person right now? There are also cases, more niche cases for teachers and school staff, like Myers versus Cincinnati Board of Education. In this one, a child committed suicide due to bullying that they experienced at school, and the parents basically sued the staff, the faculty of the school, saying that they knew and that they should have done better. But qualified immunity mapped on there as well. So, in conclusion, why do we need qualified immunity? I think the main reasons we need qualified immunity, I think really the core of qualified immunity is those split-second scenarios that we want officers who are tasked with a couple decisions, maybe all of them with pros and cons, to be able to make the decision that they believe will protect the public, to be able to act without hesitation when they need to, and without the fear that they'll be, burdened with frivolous lawsuits. I think, in addition, we want to encourage not just police officers, but government officials to take these jobs where they're asked on a day-by-day basis to make those split-second decisions. I don't want government officials to feel like if they take this job, there's a chance that a gut decision they make doing what they think is right for the public will cost them financially, will ruin their reputation, and will wind them up in court. So I think that's another really big reason why. And I think, qualified immunity, again, is not absolute immunity. So it doesn't map onto egregious criminal cases. I don't think it's this, bulldozer that tramples on people's civil rights. It is imperfect, and that second prong, I think, could use, some tweaking maybe in the future. But I think in general, what qualified immunity does for police officers and other government officials is it allows them to make split-second decisions that protect themselves, that protect the community, and that ensure that they can do their job to the best of their abilities without feeling like there's this ever-looming threat over their head. So that'll be my sort of basic defense of qualified immunity. And with that, I'll kick it over to Troy.
I'll leave this uncapped. I make notes for myself. All right. Well, and now for something completely different. I'm arguing in favor of abolishing qualified immunity. Now, before I get entirely into my full-blown argument, for the history buffs among us, I'd like to get a little bit more into the history of qualified immunity, at least in part because I have the time and because I think it's kind of a fun history. So, Section 1983 of the Civil Rights Act was passed in 1871, and it was intended to protect the constitutional rights of recently freed slaves. So what does that mean? It means that any state actor who violates someone's constitutional rights shall be liable, and the shall implicated strict liability. For those of us who are joining us without a legal background, strict liability means if you did the thing, then you get punishment for it. There's not really any grounds for a jury argument for it. But we see our first introduction to what will eventually be qualified immunity with Little v. Barimi, which is a fun little case where Captain Little of the Navy allegedly illegally captured a ship during a quasi-war with France that was going on. So at the time, federal law permitted us to capture ships going to but not from French ports. And President Adams, being how President Adams was, issued a broader instruction to capture ships coming from French ports as well. And this is what Captain Little did. So he started capturing ships that were coming from French ports. And when he was charged with his crimes under federal law, Chief Justice Marshall considered the idea of a good faith argument or a good faith defense for unlawful acts. But in the end, it was rejected, and it was stated that you violated somebody's rights, therefore you're liable. And we didn't see this come up again until Myers v. Anderson, where state officials alleged to have violated the 15th Amendment on the basis of racial discrimination in voting through enforcing unconstitutional state statutes were charged. And the officials argued that even if it were unconstitutional, that they acted in good faith, so they shouldn't be held personally liable. So this was the second big moment where we hear of a good faith defense, and it was also struck down there. But 50 years later, in Pearson v. Ray, as Jesse properly stated, we get the Supreme Court overturning Myers v. Anderson, creating a good faith defense for the beginnings of what would be qualified immunity. This then led to Harlow v. Fitzgerald, where we see the modern version of qualified immunity. And I want to accent especially that what we see today for qualified immunity is, in reality, plaintiffs have to essentially find an identical case in the same jurisdiction in order to get redress for the violation of their constitutional rights. Jesse talked about Baxter v. Bracey, which we'll come back to in a moment. I'll try and find a different example to keep you guys entertained as well. But my argument is essentially two prongs. First, that qualified immunity fails to achieve its policy goals and is therefore kind of irrelevant anyways. It's not necessary. And second, that qualified immunity makes it impermissibly difficult to actually even prevail on a Section 1983 claim. So let's go ahead and start with my first prong of my argument. So qualified immunity fails to achieve its policy goals. So there's essentially three arguments that I want to make here. So three little subsections. First, that qualified immunity fails to, that it does not shield officers from financial burdens of lawsuits. Second, that it doesn't shield officers from the burdens of litigation in filed cases. And finally, that qualified immunity does not protect against overdeterrence. So beginning with the fact that it does not shield officers from the financial burdens of lawsuits, Pearson elucidated the concern that qualified immunity is necessary because, like Jesse said, we don't want officials afraid of doing their jobs. I agree. I also don't want officials to be afraid of doing their jobs. I think regardless of whether you are a police officer or a firefighter or EMT, being confident in knowing that you can do what you're going to do to the best of your capability without getting the pantsuit off of you is extremely important. But this fear is kind of unjustified. In fact, officers are more likely to be struck by lightning than to contribute to a settlement or judgment over the course of their entire career. The money to satisfy monetary awards when they do occur comes from the public and not themselves. So it comes from us, from you, the taxpayers. So in a study of 81 state and local law enforcement agencies, it was found that officers almost never contribute to settlements or judgments. Among 44 of the largest agencies sampled, officers contributed to settlements in 0.41% of cases. Additionally, officers paid about 0.02% of the total awards to plaintiffs when damages were awarded. So officers almost never pay. Additionally, officers almost never pay for defense counsel because counsel is provided, again, by either the taxpayers or the union itself. It's either by the municipality's insurer, or the union itself. So there's really no concern that needs to be had for officers to think, well, if I maybe overreach a bit, or if I do my job and I mess up, that it's going to come out of their pocket. It usually doesn't. 99% of the time, it doesn't. Second, qualified immunity does not shield officers from the burden of litigation in filed cases. So another reason brought up for why we might want qualified immunity is to protect officers and other public officials from dealing with litigation in the first case. So we all know as future attorneys, there are a few litigators in here as well, that litigation takes years upon years and is extremely expensive and time consuming, even when you don't count for the monetary expenses. This was brought up in Harlow that it's necessary as a protection from the burdens of discovery and trial in insubstantial cases, so cases that should be rightfully dismissed. But we already have sufficient protections for these things. So we already have things like 12b6 motions. We already have summary judgment motions. If this is the driving force of qualified immunity, then it's particularly bad at protecting officers from actually going to trial, if that is what it's meant to do. So, for example, a study of 1,184 lawsuits filed against law enforcement officers and agencies across 5 federal districts came up with some interesting results. First, that 7 were dismissed on qualified immunity grounds before discovery, and only 38 were dismissed on qualified immunity grounds before trial. This means that the bulk of lawsuits were going to trial. or if they were dismissed, were not dismissed for the grounds of qualified immunity anyways. So why is qualified immunity so bad at screening these improper cases? It's simply because there are so many more effective ways that we can get rid of and screen for non-meritorious actions. So I mentioned earlier that there's summary judgment, that there's 12b6 motions to dismiss. Of the 1,184 suits mentioned previously, 126 were dismissed before defendants responded because plaintiffs filed frivolous claims, failed to serve defendants, or failed to prosecute their cases. Just gonna put these down, I guess. Lastly, qualified immunity doesn't protect against overdeterrence. So overdeterrence meaning people maybe don't want to become a teacher or a police officer because they're scared of getting sued, or because they're scared of getting sued. The court fears that damages actions deter citizens from going into public office, becoming police officers, things like that. And there are 3 reasons to believe that qualified immunity doesn't actually serve as a shield against overdeterrence anyways. So first, there's little evidence to support the concern that the threat of litigation, and I'm going to quote from the court here, dampens the ardor of all but the most resolute or the most irresponsible public officials. In fact, most officers believe that lawsuits deter unlawful behavior and that officers should be subject to civil liability. Second, evidence suggests that the threat of civil liability does not deter people from becoming police officers or deter officers from vigorously enforcing the law. And lastly, even if we assume that the threat of liability does deter officers and future officers, it's unclear how qualified immunity would mitigate those deterrence effects. There are indemnification practices and litigation dynamics that already shield government officials from financial sanctions, which obviate the need for qualified immunity to serve that role. Additionally, as I stated before, it does little to shield government officials from discovery and trial. And if the burdens of discovery and trial do discourage job applicants or chill behavior, there's very little that qualified immunity would be able to do in the first place. This is something that you assert as a last-ditch effort. As litigators, we should also know what's the first thing we think of? 12b6, motion for summary judgment. These are the things that we think of first. Qualified immunity is shown multiple times, thousands of times, to not be that thing. The second part of my argument is that qualified immunity discourages the filing of meritorious suits by making it overly burdensome to prevail on civil rights 1983 claims. So remember the standard. You must find a case of precedent or a concurrence of persuasive authority within your own jurisdiction to clearly establish a right in order to enjoy remedies. This is extremely, extremely difficult to attain. Jesse already talked about Baxter v. Bradley, or Bracey, where a very similar case, the only difference between the 2 cases, that in one, a suspect was laying down with his arms at his side, and at another, where the suspect was standing up with his hands raised. That was all that it took to distinguish those 2 cases, and for the Sixth Circuit to say qualified immunity attaches here, when it didn't in the first case. Imagine how difficult that would be as a plaintiff to actually prevail on any kind of Section 1983 claim. It's not just about finding an analogous case. It's about finding the exact same case that has happened before. Another case is Corbett v. Vickers, where police caught up to a suspect on the front yard of a family whose children were playing outside. The officer tackled the suspect and made everyone lie down in order to secure the scene. And after the suspect was already handcuffed, a dog came out from under the house. The officer drew his gun and shot at the dog, and he missed. And the dog retreated back under the house. Keep in mind, this is after he already has the handcuffs on the suspect. The scene is contained by now. Later, The dog reemerged, no barking, no threatening movements. It just came out. The officer once again pulled out his gun and shot at the dog. Again, he missed, but this time he hit a 10-year-old boy in the leg, which almost killed him. The 11th Circuit granted qualified immunity because there was no case on point that said specifically, when you are in this situation where you have just tackled a suspect on a neighbor's lawn with kids on the lawn, and a dog comes out once and you shoot and miss, and the dog comes out a second time and you shoot, that you maybe shouldn't have shot that second time. That is the only reason why the court said there's qualified immunity here. The officer didn't need to reasonably know that maybe he shouldn't be popping off shots. My point is that the current state of qualified immunity permits officers nearly unrestrained permission to act in nearly any way, and this leads to very bad outcomes. It deprives officers of public trust and accountability and the credibility that they need to do their jobs. It holds officers to a far lower standard of accountability than anyone else is held to. Keep in mind, the vast majority of us are held to a standard of a reasonable person. Right? I don't think any reasonable person would act in the way of the officers in these past cases that we've discussed. And it severely undermines the deterrent and remedial effects of what was supposed to be our primary means of holding public officials accountable for their unconstitutional misconduct. Keep in mind that this all started from trying to hold accountable a ship's captain. The goal was to make sure that we can hold people accountable for their unconstitutional actions. The law has completely flipped with qualified immunity.
Mr. Gervasio, rebuttal?
Alrighty. And just quick introduction, I might be taking pictures from yours.
That's fine. Okay, so I'll start off with the over-deterrence argument. So you said that evidence that threats of civil liability, there's evidence that threats of civil liability doesn't deter police from being officers. And I think you said that officers don't seem to cite civil lawsuits as a reason why they would want to become a police officer. I mean, I guess there's two ways to interpret that. You know, the first way is that if you took qualified immunity away, civil lawsuits would not deter officers. The second is that qualified immunity is working, and that's why officers aren't deterred by civil lawsuits. Now, I don't know what the top reason why a police officer or why someone who was deciding they might want to become a police officer would decide not. But I would wager, and I think it's a fair wager, that it's probably the inherent danger that comes with being a police officer. And that, again, is why I think, these split-second decisions are at the core of qualified immunity. You talked about similar cases and how we're held to the standard of a reasonable person, and that you don't think any person would act in that way that you described in those cases, and we would call it reasonable. And there are some cases where I think that's the case, but with most of these cases, these split-second scenarios, I think there's a difference between a reasonable person and a police officer making a decision that he thinks is going to protect the public or himself. I mean, you can imagine scenarios where there's, a getaway driver barreling down the highway and the cop has to decide whether or not to take a shot at the car, and maybe he hits that guy. I don't know if that's, it's hard to imagine if that's a reasonable person, but then again, I've never been in that circumstance. Most of us have not been in that circumstance. And so I think when we talk about that reasonable person standard, there has to be a discussion of the nature of the job and the fact that they do this every day and the fact that they're sort of entrusted to protect the public. And I don't want them in most cases to hesitate when they have to make those split-second decisions. So another thing I'll say is you said qualified immunity is nearly unrestrained. it leaves cops with behavior that is nearly unrestrained, I think was something along the lines you said. I, again, don't think that's true. It's only been granted in around 53% of cases. I think in many cases when the right has been, clearly established, the courts make the right call and say that qualified immunity doesn't apply here. I think it's sort of a bolster to, the decision-making processes that a police officer has to go through. And I think as well, you did mention, and I think my limited research into this said that most police officers don't end up paying out of their own pockets, but there are times when they do, and there is still the threat of being burdened financially. There is the threat of being burdened by just the process of going through a lawsuit, and I think qualified immunity serves as sort of a second barrier that protects cops from that too, and other government officials. I'll also say, going back to the reasonable person standard, we're talking about abolishing qualified immunity today indefinitely, not just for police officers. I think you mentioned a couple cases where police officers, there are good arguments that those police officers didn't act like reasonable people. There are good arguments that maybe if you or I were a police officer, we would have acted differently. I don't know that that's true, but maybe. But with officials like EMS, I think it gets a little bit more complicated, and I don't see many arguments that they should be stripped of their qualified immunity. I think it's a necessary bolster for them, again, to make those split-second decisions that are inherent to doing the best work they can for the person under their care. I think when we talk about government officials broadly, I hear less, argument from the opposing side that we should strip qualified immunity from them. It seems focused on police officers, which, obviously the brunt of the discussion has to do with police officers because that's the most controversial. But I think in general, most government officials do need qualified immunity for those split-second scenarios. I don't think it's nearly unrestrained, and I think that applying a reasonable person standard, or just saying that this is not the way a reasonable person would act, we need that hold into it. I think that sort of ignores the inherent danger in these jobs. And I think that it's hard to imagine, as someone who's never been in these scenarios, what the reasonable thing to do is when someone is holding a human shield or when there's a getaway driver barreling down the highway. But I want to have faith in our police officers and to trust them to make those decisions, and for them to know that there's not going to be this burden hanging over their head. And I appreciate that you do too, and that you said that confidence is essential when police officers and other government officials are going about their duties. I think that's true, and I think confidence is essential, again, in those split-second scenarios that I think are at the core of qualified immunity.
All right, well, I will keep my response to the response fairly brief. So once again, I want to reiterate that I think that confidence is a very important part of public service jobs. I think it's extremely important for the police and for EMS, firefighters, I think you mentioned originally in your original outline as well, and teachers. But I think that there is a balance to strike between saying, in order to prevail on a Section 1983, you have to find not just an analogous case, but the case. And saying, screw you, you have no protections whatsoever. So I think that there's a balance that we can look at here. And what I've wanted to illustrate is that when we compare the pros and cons of having qualified immunity and the damage that it can cause and has caused and frequently does cause, compared to the protections that are already out there for public officials, we can even look outside of police officers and look at public officials in general. It seems to me clear that qualified immunity just is fairly irrelevant. It's there's a saying in German engineering that all German engineered things are overbuilt. I imagine that qualified immunity is maybe one of those things, that it's just a bit overbuilt. when it comes, is there a threat of facing fees in any lawsuit? Sure. But paying out 0.02% of the time is astronomically low. That's exceedingly low. I imagine that's lower than the attorneys that have to pay out for malpractice suits. And yet all of us still are, at least I think, planning on becoming attorneys. So it seems like that's not exactly a huge deterrent. When it comes to, now you said EMS, you pointed out EMS and government officials specifically, saying that you want there to be the confidence in a split-second decision to be able to step up to the plate. And I agree with you, but I don't think that qualified immunity actually does anything to protect their confidence to do that. Especially when we have things like summary judgment, 12b6 motions to dismiss for failure to state a claim. And it just doesn't seem to me that let me put it this way. Even if something were to go to trial, even if there was a non-meritorious claim that were to get past a 12b6, that were to get past a summary judgment motion, that were to get past some sort of like preliminary injunction or something like that, you go to trial and you are now able to tell the jury why what you did was reasonable in the moment. And when the only cost is your time, because it's not just police officers that have unions or have attorneys paid for by the state or the municipality, it's also firefighters, it's also government officials, it's also EMS and teachers. It seems like that's a small price to pay to protect and ensure the protection of all of our civil rights.
All right, with that, I would like to thank both of our speakers. I think this has been a phenomenal debate. I think both sides have offered a cogent explanation and rebuttal for their position. But without any further ado, I think it is time for this body to vote on whether or not we will accept the motion. I remind the members that the motion before the floor is resolved, abolish qualified immunity. So therefore a vote would be a vote to abolish it, and a vote against is a vote not to abolish it. So with that, all in favor, please raise your hands. All right, all opposed, please raise your hands. All right, with that, the motion fails. But I'd like once again to thank both of our speakers. I think you both did a phenomenal job presenting today, and I think both sides had a strong defense. And I'd like to once again thank our members. So without any further ado, I think that concludes this inaugural meeting of the Lincoln Douglas Society at Cornell Law School. Thank you.